Welcome to Chapter 5 of Medical Law and Ethics, Professional Liability and Medical Malpractice. Over the course of this chapter, we will cover the following learning outcomes. We'll define liability, law of agency, and respondent superior, describe the reasonable person standard, standard of care, and duty of care, briefly outline the responsibilities of healthcare practitioners concerning privacy, confidentiality, and privileged communication, explain the 4 elements necessary to prove negligence, or the 4 Ds, outline the phases of a lawsuit, discuss patient safety standards as related to medical malpractice prevention, and identify when the use of alternative dispute resolution, or ADR, in resolving medical malpractice claims is most effective. This is a list of key terms that we will cover throughout this chapter. We'll start out with liability. All competent adults are liable or legally responsible for their actions on the job and in their private life. The law of agency. So this is a lot of technical terms. It's a law governing the relationship between the principal and an agent. So the principal in most cases would be the employer, and your agent would be your employee. This law may be expressed or implied. So here again, the agent is one who acts for another, or the employee. And then your third party would be your patient, customer, etc. The essential basis of the law of agency is that the employer, or principal, is always liable for the actions of their employee or agent. Even if the employer was not there when the event occurred, as long as his employee was acting within the scope of what they are supposed to be doing, they can be held responsible for the actions of their employee. Agency often comes up in personal injury cases when the plaintiff sues both the defendant and the defendant's employer under the rule of respondent superior, which literally means let the master answer. It is a doctrine under which the employer is legally liable for the acts of his or her employees. For this lawsuit to succeed under respondent superior, the injured plaintiff must prove the injury to the plaintiff occurred while the employee was working for the employer, the injury was caused by something the employee would ordinarily do while working for the employer, and the employer benefited in some way, however small or indirect, from the action the employee was performing when the injury occurred. On top of being liable for their employees' actions, employers are also liable for things such as grounds and buildings, automobiles, or employee safety. Inside of their buildings and grounds, they need to keep up and maintain those grounds. Things like slippery sidewalks in the winter, make sure there's not wet floors, make sure that doors and windows are functioning correctly, that there's not ways for employees and or third parties or patients / customers could get hurt on the grounds. As far as automobiles, if the employee uses either their own or the employer's automobile in routine daily work, the employer must have enough insurance for liability in the event of an accident. And lastly, employee safety. Employers must provide a reasonably comfortable and safe work environment. State and federal regulations apply, but they vary. So employers should check with OSHA, or Occupational Safety and Health Administration, standards and make sure that they have proper protocols for things like handling of hazardous laboratory waste and materials. Liability exists with all of these different actions. Standard of care and duty of care. The standard of care is a level of performance expected of healthcare workers carrying out their professional duties. And duty of care is an obligation of healthcare workers to both patients and non-patients. So physicians always have a duty of care to patients with whom they've established that physician-patient relationship. But they also have a duty of care towards people who are not patients, such as their family members, former patients, even office personnel. Generally, if the actions or omission of actions within the scope of a healthcare physician's job could cause harm to someone, that person is owed a duty of care. An example of this is simple things, such as signs on a room of a patient that has a communicable or contagious disease, or labeling of sharps or biohazard materials so that custodians don't have an increased risk factor while handling those materials. We are responsible for our actions or our failures to act under the reasonable person standard. This is a standard of behavior that judges a person's actions in a situation according to what a reasonable person would do under similar circumstances. That's why we may be charged with negligence. If they're injured because we failed to perform an act, or we did perform an act without the proper level of care, we are negligent. Professionals, or people who are trained specifically to do specific tasks, are held to a higher level of care than regular laypersons or untrained people. If a patient is injured because we failed to exercise the care and expertise that we've been trained with, or that a peer, a similar professional with the same training and expertise, would be expected to perform with, then that professional may be liable for negligence. This also means that a physician would be held to the standards of his peers or people with comparable experiences and expertise. So a specialist would be held to a higher standard than a general practitioner. He'd be held to the standard of other specialists in the same field, whereas a general practitioner would just be held to the standards of other general practitioners. The following guidelines can help all healthcare professionals stay within the scope of their practice and operate within the law and policies of their facilities. They start with practicing within the scope of their training. You always want to only be doing the things that you have been trained and hired to do. You want to use a professional title commensurate with your education or experience. So you don't want to be claiming to be a doctor if you are a nurse, and you don't want to be claiming to be a nurse if you're a patient care tech. You want to use the title that equals your education and experience. You want to maintain confidentiality. Confidentiality is so important in healthcare. It's the basis of HIPAA, it's the basis of all of these things. If you are told something in confidence or you are exposed to information through the duties of your job, you want to keep those things in confidence. Prepare and maintain health records. Essentially, if it's not written down, it didn't happen. So you always need to be noting and documenting through all of healthcare. Leads us into our next thing, document accurately. Make sure you're writing down the right amounts in the right measurement. Use appropriate ethical and legal guidelines for patient information. So you should only be getting into the amount of information you need inside of the duties of your job. Even if you have access to their entire health record, you need to only be looking into the parts that are in the need to know for the appropriate portions of your job. You also want to follow your employer's established policies. If they have things written down that they are done a specific way, that is the way you should do them while you're in their employment. Different facilities are going to have different policies. Follow the appropriate legal guidelines. Make sure you're staying within the scope of your job. Make sure you're following the proper protocols to do it correctly. Maintain and dispose of controlled substances properly. So this could be everything from medications to biohazardous materials. Make sure you're following, again, the proper protocols. Follow risk management protocols. Doing things in a certain process, in a certain way to minimize risk. Meet the requirements for credentialing. So make sure that you're maintaining your CEUs, that you have the proper credentials for yourself and for the facility to be endorsing you as their employee. And lastly, help develop and maintain policies. If you feel that there's improvements to be made in a policy, speak up. A lot of times they can be changed if they're out of date or something else, but you have to speak up and have those things changed officially, not just change them in practice. If policies have changed, you want them to change in writing. That way you have backup and evidence if legal suit should arise. We are going to expand upon confidentiality because it is such a major component in healthcare. So confidentiality is the act of holding information in confidence, not to be released to unauthorized individuals. This includes things like your patient-doctor confidence or privileged communication, information that's held confidential within that protected patient-doctor relationship. If you are going to release that information, you want to always obtain signed consent of who it can be released to. You want to avoid judgments about patients' morals or having personal opinions about what they're saying. Their financial information is also confidential. If you are on the phone, be careful to not use the patient's name if others are nearby where they can overhear the conversation. You want to use extreme caution when leaving messages on voicemail. In fact, most initial paperwork at doctors' offices has a question regarding whether any medical information can be left on a voicemail or just a very generic message asking you to call them back. You want to keep patient information out of sight or from other patients or visitors. Make sure that if you have their paperwork out, that it's turned face down or it's kept in a location where they can't see it. And you want to make only legal exceptions to disclosure. So you want to only release those things to people who are in the need to know, or ones that they have signed consent to release it to. The unintentional tort of negligence is the basis for professional malpractice claims and the most common liability in medicine. So when healthcare practitioners are sued for malpractice, the term generally means any deviation from the accepted medical standard of care that causes injury to a patient. Hospitals have also been found guilty of negligence because they also have a duty of care to patients, including to only grant privileges to competent physicians, to supervise medical treatments, and to review competence of these physicians regularly. Professional liability claims tend to come in one of three ways. They're all based on the root word feasance, which means the performance of an act. So malfeasance, or the performance of a totally wrongful and unlawful act. Somebody acting outside of the scope of their job and doing an incorrect action. Or misfeasance, the performance of a lawful act in an illegal or improper manner. So somebody performing within the scope of their job, something like a nurse changing sterile bandaging on a wound, but not doing it in a sterile procedure, whereas their hand gets infected and leads to additional problems. Or nonfeasance, the failure to act when one should. So the example in the book for this is an MLT at an accident, but realistically, anyone with a BLS or basic life skills, CPR certification, should be acting when there is a situation at hand that requires CPR. It is your duty to act in those scenarios. So nonfeasance would be charged when someone fails to act when they should. So to remember these and differentiate between them, they all have the base root feasance, which is the performance of an act. Mal translates to bad or poor. Miss is usually translated into the improper or wrong, and non simply is to not do something. Non whatever is to not do it. 4 elements are needed to prove negligence in healthcare situations. These are sometimes called the 4 Ds of negligence. First of these is duty. The person charged owed a duty of care to the accuser, so they had an obligation to do something for the accuser. Second of which, dereliction, the healthcare provider breached the duty of care to the patient. Third, direct cause. That breach of duty of care to the patient is what caused the injury. This injury can be an actual injury, physical, mental, emotional. And lastly, damages. The healthcare provider's dereliction of duty is what caused the injury to the patient. So sometimes at the end of a case, damages are also referred to as the court-ordered monetary awards to patients, given as a result of legally recognized injuries to the patients. So the damages has kind of a twofold answer. One, damages are the injury to the patient, and 2, damages are the monetary awards given to the patient. Following through with the secondary definition of damages, where it's monetary awards to patients, there are a few different types, the first of which is general compensatory, which is to compensate for injuries or losses due to a violation of patient rights. So these could be things like physical disabilities, loss of earnings, mental anguish, loss of a service of spouse or child, things up to now and things in the future. In these cases, it's the loss that must be proven. Moving on to special compensatory, to compensate for losses not directly caused by the wrong. So usually these are things like additional medical expenses, follow-up procedures. And in these, both the dollar amount and the loss must be proven. Next, we have consequential, which is to compensate for losses caused indirectly by a product defect. So the loss should be covered by the product warranty or personal injury. And usually there is no limit on damages for this if it caused personal injury. The next is punitive, which is there to punish the offender. They want to know how serious was the breach of conduct and how much can this defendant afford to pay. It is there more to teach them a lesson to not have a repeat offense. And lastly is nominal, and that's there to recognize the rights of patients were violated, although there was no actual loss proven. So this is more of the legal rights of that patient were violated, but they can't prove that there was actual damages caused to the patient's lifestyle, health, anything else. Sometimes negligence cases are determined by the doctrine of common knowledge, or res ipsa loquitur. The thing speaks for itself. Negligence in these cases is obvious. But in order for res ipsa loquitur to apply, 3 conditions must occur. First, the act must be under the defendant's control. Then second, the patient must not have contributed to this act. And third, It must be apparent that the patient would not have been harmed if reasonable care had been used. Things that usually fall under this are things like leaving foreign objects in the patient's body during surgery. Sometimes it's surgical sponges, sometimes it's utensils. Accidentally burning or injuring this patient while they're under anesthesia. Damaging healthy tissue during surgery, nicking something nearby to the surgical site, causing additional problems, or causing an infection by using unsterilized instruments. In today's society, there's no reason for these things to occur. Also, most states have enacted wrongful death statutes that allow patients' beneficiaries to collect from the practitioner for loss of that patient, of their future earnings, when it's due to negligence by the practitioner. Some states even allow the prosecution of a healthcare practitioner under criminal statutes for the wrongful death of a patient. The phases of a lawsuit. The typical malpractice or negligence lawsuit proceeds as follows. First, a patient feels he or she has been injured. The patient then seeks the advice of an attorney. If the attorney believes the case has merit, then they request copies of the medical records. He reviews the records and makes sure that the appropriate standard of care was met, or if there was negligence. If there is sufficient evidence of negligence, it will often move into the pleading phase. During the pleading phase, the plaintiff's attorney will file a complaint with the clerk of the court. In this document, the plaintiff states his or her version of the situation and the amount of money sought from the defendant for their injury. A summons is issued by the clerk and is delivered with a copy of the complaint to the defendant, directing him or her to respond to the charges. If they fail to respond to this, sometimes they can lose strictly by default. The defendant's attorney files an answer to the summons, and the copy of it is sent to the plaintiff. In this document, the defendant presents his or her version of the case, either admitting or denying the charges. The defendant may also file a counterclaim or a cross-complaint. If a cross-complaint is made, then the plaintiff also files a reply. In the interrogatory or pretrial discovery phase, subpoenas and depositions may occur. It starts with the court setting a trial date, then pretrial motions may be made and decided. Things like the defendant requesting a dismissal or the plaintiff amending the original complaints, and or either side may request or change a venue or ask that the trial be held in another place. Discovery procedures may be used to uncover evidence that will support the charges when the case comes to court. A court order, called a subpoena, which is a legal document requiring the recipient to appear as a witness in court or to give a deposition, may be issued commanding presence of a physician or other healthcare professional in court and requiring that a deposition or a sworn testimony given and recorded outside the courtroom during the pretrial phase of the case be given. An interrogatory may be requested instead of or in addition to a deposition. This is a written set of questions requiring written answers from a plaintiff or defendant under oath. The subpoena may also command a witness to appear in court and to bring certain written medical records with them. Is called a subpoena dos tecum. This is a legal document requiring them to bring certain records to court to be used as evidence in a lawsuit. Contempt of court is willful disobedience and or open respect of a court, judge, or legislative body. It's punishable by fines and imprisonment. Pretrial conferences are common and may be called by the judge scheduled to hear the case. During this, the judge will discuss issues in the case with both attorneys. This helps avoid surprises and delays after the trial starts and often leads to out-of-court settlements. Moving on to the trial phase. First, a jury is selected if one's to be used, and the trial begins. Opening statements are made by both lawyers, both for the plaintiff and the defendant, summarizing what each will prove or disprove during the trial. Witnesses are called to testify for both sides, and they may be cross-examined by the opposite attorney. Each attorney makes closing arguments and reiterates the evidence presented that supports his or her version of the case. No new evidence can be presented during closing arguments. The judge will give instructions to the jury, and the jury retires to deliberate. Once the jury has reached a verdict, they hand it to the judge, and the final judgment is handed down by the court. The judge bases their decision for the final judgment upon the jury's verdict. Lastly, the appeals phase. If either the plaintiff or the defendant is unhappy with the decisions made in the case, an appeal may be made for the case to be reviewed by a higher court, especially if the evidence indicates that errors were made or there was an injustice or impropriety in the court proceedings. During the appeal, the judge has the option of affirming, reversing, or modifying a decision. Judgments are only final when all options for appeal have been exercised. Roughly 9 out of 10 lawsuits are settled out of court, but healthcare practitioners are often asked to give testimony. Sometimes this is given in court, and sometimes in an attorney's conference room in pretrial proceedings called a deposition. There are essentially two types of depositions. Discovery depositions will cover material that will most likely be examined again when the witness testifies in court, and depositions in lieu of a trial that are used instead of a witness in-person testimony in court. Because they only have one opportunity to question these witnesses, questions are very thorough, and the witness should carefully consider his or her answers. Witness testimony comes in two types: fact testimony and expert testimony. Fact testimony, the witness only provides facts he or she observed, things like how many times the doctor saw this patient, the appearance of or behavior of the patient on a particular visit, and other observations that they themselves have seen. In fact testimony, their powers of observation and memory are more important than his or her professional qualifications. In fact, a healthcare practitioner giving fact testimony is not allowed to give his or her opinion, only the facts. In expert testimony, only experts or specialists in a particular field have the education, skills, and knowledge and experience to give expert testimony. In medical negligence lawsuits, physicians are usually called upon to be expert testimonies for the defense. If the defendant is a specialist, the expert witness will usually be a specialist in the same specialty. Expert witnesses usually do give their opinions on the facts because they are looking to determine how they would act in the same situation. It is ethical and acceptable for expert witnesses to accept a fee for the time taken from their regular job preparing for their expert testimony. Here's a short list of patient safety standards provided by the Joint Commission to help prevent lawsuits. First, make sure patients receiving blood receive the correct blood. Make sure test results are the right patient and done on time. Label all medications in all containers before a procedure. Identify medications patient is taking and compare them to new ones to prevent side effects. Check alarms on medical equipment. Use the CDC guidelines for hand cleaning. Use proven guidelines to prevent infections, blood infections from central lines, and infections after surgery. Always identify suicidal patients. And make sure the correct surgery on the correct patient on the correct place on the patient's body is done. While all of these sound like things you wouldn't have to think about, they are all things that have happened in the past. Alternative dispute resolution, ADR, or techniques for resolving civil disputes without going to court has become increasingly popular in recent years. Part of this is due to the overcrowding of court calendars. ADR uses neutral mediators and arbitrators to come to decisions to the benefit of both parties. In healthcare, some of the advantages of ADR are they use a more qualified decision maker who better understands medical terms and procedures than the average jury of laypersons. It reduces expenses in settling a claim. Sometimes damages awarded in court don't even cover their medical care or legal fees. Reduces trauma associated with the two parties facing off, and it also reduces having to relive the experience as you would in a lawsuit. It improves the quality of experts used in both sides of the argument because they're not paid medical testimony professionals as they may be in a court of law. Reduces the number of frivolous medical malpractice claims because once both sides are heard, sometimes the plaintiff decides proceeding with the lawsuit is unnecessary. And it preserves relationships and reputations because ADR procedures are confidential and do not become a part of public record. Mediation is one of the forms of alternative dispute resolution, or ADR. Mediation is voluntary, has a neutral third party as the mediator, and the mediator, while he cannot impose a solution on the parties involved, tries to get the two parties to come to a beneficial solution for both of them. If mediation does not solve the problem, a lot of times it can move into arbitration. Arbitration, again another form of ADR, is a method of settling disputes in which opposing parties agree to abide by the decision of an arbitrator. The arbitrator is chosen in a few different ways, either by the court, by the American Arbitration Association, or each party selects an arbitrator and those two arbitrators select a third. Arbitration may be binding, in which the two parties agree to accept the decision in lieu of going to trial, or non-binding, in which the disagreeing parties may choose to go to trial if neither party likes their decision. People in favor of alternative dispute resolution claim these methods are faster and less costly than court adjudication. Critics claim that malpractice cases are best decided when all the information is brought out, as in pretrial discovery procedures. Critics also argue that selecting arbitrators acceptable to both parties can take weeks, months, even years, and attorneys' fees and damage awards can be just as costly as court-tried cases. Thank you for joining me for Chapter 5 of Medical Law and Ethics, Professional Liability and Medical Malpractice.